Good morning, this is your Kelso Report for Tuesday, September 6th, and I'm your host, Clark Kelso. Settlement in cases involving joint tortfeasors is a complex process. Fortunately, Section 877.6 of the Code of Civil Procedure establishes a clean mechanism for a plaintiff with claims against multiple tortfeasors to settle with one or more of the joint tortfeasors, where that settlement, if approved by the court as a settlement entered into in good faith, lets the settling tortfeasor walk away from the case without fear that the remaining tortfeasors may later come after him for additional damages. We see a great example of Section 877.6 at work in the 4th District's decision last Friday in Pacific Care of California v. Bright Medical Associates. The underlying action was a wrongful death claim which the heirs brought against the decedent's health care plan, Pacific Care. Pacific Care filed a cross-complaint seeking indemnity against Bright Medical Associates, a healthcare provider that contracted with Pacific Care to provide health care to subscribers to the Pacific Care plan. A Bright provider was involved in providing the care that led to the decedent's death from a burst cerebral aneurysm. The basis for the indemnity claim and for Pacific Care's primary defense against the wrongful death action was that under California's Knox-Keene Act, which regulates health plans such as Pacific Care, a plan cannot be held vicariously liable as a matter of law for the medical malpractice of providers with which it contracts. Just last Thursday, we reported the result of the appeal in the underlying action, Martin v. Pacific Care, where the 4th District ruled in Pacific Care's favor and ruled that it could not be held liable for malpractice committed by a Bright provider. Early on in the underlying action, Bright negotiated a settlement with the heirs for $300,000, conditioned on the trial court finding Bright and the plaintiffs settled in good faith. The trial court granted Bright's good faith settlement motion and thereafter entered an order dismissing Pacific Care's cross-complaint against Bright. In Friday's decision, Pacific Care challenged the trial court's determination that the heirs and Bright had entered into a good faith settlement. Pacific Care argued that because it could not be held jointly liable with Bright as a matter of law, there was no basis for applying Section 877.6. Pacific Care also argued that even if Section 877.6 applied, the trial court failed to take into account Pacific Care's substantial attorney's fees, which it had incurred in defending the action. The 4th District rejected Pacific Care's claims and upheld the trial court's decision. Section 877.6 provides that, quote, any party to an action in which it is alleged that two or more parties are joint tortfeasors shall be entitled to a hearing on the issue of the good faith settlement entered into by the plaintiff and one or more alleged tortfeasors. A good faith finding reduces the claims against the non-settling tortfeasors in the amount stipulated by the settlement, and also shall bar any other joint tortfeasor from any further claims against the settling tortfeasor for equitable contribution or partial or comparative indemnity based on comparative negligence or comparative fault. Close quote. The key to the court's decision is that Section 877.6 focuses on alleged joint tortfeasors. At the time of the settlement, the complaint against Pacific Care alleged both direct and vicarious liability. The allegations of direct liability were not frivolous and were not barred as a matter of law. So the fact that after trial of the underlying action, it then became clear that the plaintiff's only basis for recovering against Pacific Care was vicarious liability, and Knox-Keene barred vicarious liability, that did not change the good faith nature of the settlement. At the time when the trial court found the settlement in good faith, there was still a possibility that Pacific Care would be held jointly liable with Bright, because the complaint alleged that both contributed to the delays in the decedent's health care leading to her death. As for the amount of the settlement, Section 877.6 does not require perfect or even nearly perfect apportionment of liability. All that is required is that the settlement not be grossly disproportionate to the settlor's fair share. Pacific Care argued that the $300,000 settlement was grossly disproportionate to the $1.5 million it estimated it would have to pay in attorney's fees to defend the action successfully. Pacificare's argument here was too cute, because it also took the position that it could not be held jointly liable with Bright as a matter of law. But if it couldn't be held jointly liable, then there would be no basis in law for an action in indemnity against Bright. As the 4th District noted, quote, to preserve its attorney fee claim, Pacificare would have to concede it and Bright are jointly liable for the wrongful death. Of course, Pacificare makes no such concession, close quote. The result here is that Bright got out of the case early for a reasonable amount. Pacificare didn't do too badly overall itself. It avoided liability, and its only major expense was for attorney's fees. Moreover, it established a pretty strong precedent to support its model for operating as a Knox-Keene healthcare plan. Whether the plaintiffs could have recovered a lot more from the providers, Bright, is something we will never know. They obviously made a tactical decision early in the case to go for an insurance bad faith claim against Pacificare instead of suing the providers. So it may well be that the $300,000 was viewed by the plaintiffs as adequate compensation in the circumstances of the case. And now our one-liners. We begin with the field of torts in Samuels versus Holland American Line, where the Ninth Circuit held that a cruise ship which dropped passengers off for shoreline activities at Cabo San Lucas had no duty to warn passengers about supposedly dangerous swimming conditions on the Pacific Ocean side of Lovers Beach, because the cruise ship had neither actual nor constructive notice of any such dangerous conditions. Almost 100,000 passengers visited Cabo San Lucas in 2008 without a single report that any of the passengers who chose to visit Lovers Beach were injured while doing so. The plaintiff attempted to introduce declarations from 2 so-called expert witnesses, which alleged that it was well known in the travel industry that swimming on the Pacific Ocean side of Lovers Beach was extremely dangerous. But the district court properly struck both declarations because neither declarant established himself as an expert on the topic, and there was absolutely no substantiation or documentation in their declarations to support their naked conclusion about the alleged danger. Of course, interestingly enough, if you Google Cabo San Lucas swimming in the ocean, you will in fact see prominent warnings about swimming only in the Sea of Cortez and not swimming in the Pacific Ocean, where there are dangerous waves and riptides. One wonders whether the Ninth Circuit knows how to Google. In any event, the result is a finding of no duty, and the case is dismissed. Next, in the area of immigration, in De Osorio versus Mayorkas, the appellants were immigrants who became lawful permanent residents through the family-sponsored immigration process, which allows certain aliens to immigrate based on their status as relatives of either U.S. citizens or lawful permanent residents. When they began the process, they had children under the age of 21, who would have been eligible to immigrate with them under the Immigration and Nationality Act. Unfortunately, the process took so long that the children turned 21 before their parents were able to immigrate or adjust status. The Ninth Circuit held, applying Chevron deference to the Board of Immigration Appeals interpretation, that the applicable statutes, including the Child Status Protection Act, do not give the children any relief because they had already passed the age of 21. Next, in the area of habeas, in Payton v. Cullen, the Ninth Circuit affirmed the district court's rejection of William Charles Payton's remaining habeas challenges to his conviction and death sentence. His original federal habeas claim was resolved by the district court in 1999 with the court's rejection of his guilt phase challenges, but a finding in his favor on an instructional error claim. The case then produced an opinion by a Ninth Circuit 3-judge panel, an in-bank opinion, a Supreme Court remand for reconsideration in light of the Anti-Terrorism and Effective Death Penalty Act, another in-bank opinion, a reversal by the Supreme Court, and then a remand to the district court to consider the remaining claims not already addressed on the merits. So, a decade later, the district court denied the remaining claims. One claim challenged the lethal injection protocol, but that claim is now not ripe, given the changes California is making to its lethal injection procedure. So although the court denied his original challenge to the protocol, he is free to challenge the new protocol. The court otherwise rejected a claim that his lawyer had not conducted a sufficient investigation to develop mitigation evidence and that the prosecution had committed a Brady violation. In both instances, the court held the error, if any, would not have affected the sentence. So that leaves just the lethal injection challenge. We'll see how this case resolves itself over the next multiple years. Next, we have an insurance case. In R.R. Street & Co. versus Transport Insurance Company, the Ninth Circuit faced the question of which jurisdiction, state or federal, should be the locus of litigation between two companies and their insurance company to determine coverage issues arising out of the underlying toxic tort litigation. Through a complex series of suits brought in state and federal courts between and among multiple insureds and several insurance companies, we ultimately ended up with an action for damages that the insureds had brought in federal court, a declaratory judgment action that the insurance companies had earlier instituted in state court, but which had been removed to federal court, and a related third action that had been pending for several years in state court. The federal district court decided to exercise its discretion under the federal declaratory judgment statute to remand the declaratory judgment to state court, and it held that it should abstain from considering the federal damages action under the abstention doctrine known as Colorado River Water Conservation District versus United States, which is used in very narrow circumstances to permit complex state law litigation that largely duplicates a pending federal action to proceed in state court in the interests of efficient judicial administration. The Ninth Circuit affirmed, sending the entire set of federal claims back to state court, where they will be consolidated with a pending complex litigation matter in the Los Angeles Superior Court. Now we close with discovery and discovery sanctions. In Kane versus the Grand Holdings, a 15-year effort to collect $37 million in damages resulting from the defendant's purchase of one of its subsidiaries ultimately led to the imposition by the Superior Court of $75,000 in discovery sanctions. The plaintiff was attempting to prove that the defendant was the alter ego of a company, MTC, against which the plaintiffs had secured a $37 million judgment. The defendant repeatedly refused to provide the plaintiff with discovery pursuant to court orders, forcing the plaintiff on two separate occasions to file motions to compel. When they finally produced 55,000 pages of financial, accounting, banking, and transaction records, the plaintiffs discovered the records in such a state of complete disorder that they were forced to spend $75,000 of lawyer time to put them in order. Defendant claimed that they had turned the documents over in exactly the condition they found them. But when the court ordered defendants to produce witnesses who could so testify, the defendant produced two declarations of employees, neither of whom had personal knowledge of the condition of the records. The Superior Court at that point granted the plaintiff's motion for sanctions, awarding the plaintiff the cost of putting the records in order, and the Second District affirmed. This is pretty clearly a case of discovery abuse by the defendants, and it is also clear that defense counsel has lost the trust and confidence of both the Superior Court and the Second District. It's not a smart way to practice law. And that's it for today's Kelso Report. Have a great day in the law.